All right, so we're going to finish up this class. We've been talking about labor unions and employment discrimination law over the last several weeks, but more particularly over the last three weeks, we've been talking about labor unions, and that's where we're going to end this class. We've been focused mostly on the private sector labor unions. I'm going to touch, because I think it's important to talk a little bit about public sector labor relations. In other words, governmental unions. The United States Post Office has a union, all right? But it is a governmental, the United States Post Office is a governmental entity. And so what happens when you have governmental entities? How does that differ in the public sector labor relations? And it is a little bit different. So first, when you have the government as an employer, what are the differences? So for just briefly, let's look at some of those differences between the private sector and the public sector. Keep in mind, and we've discussed it before in this class, but public employers have to respect an employee's constitutional rights. All right? So if you work for a public employer, as opposed to a private employer, you have to make sure your constitutional rights are protected, if you will. The public employer has to give more notice, has to generally tell you or give you a hearing if you want a hearing. And so there are a lot more things that the public government has, or the public employer has to do than the private employer. The other thing, however, in strikes it may be a little bit different, because public employers, while they still have to recognize constitutional rights, public employers have to recognize constitutional rights. Public employers also have certain sovereignty as a governmental entity. And so they actually may be able to restrict the scope of collective bargaining that affects their obligations. So generally, why it may be more, if you look at which one do you have more rights on, generally you may have more rights in a public sector position than you do in the private sector. There are also certain limitations upon those rights in the public sector, and that comes through particularly when we look at unions in the public sector. So for instance, the scope of collective bargaining that we talked about with private sectors may not be as broad in the public sector. Dispute resolution, you certainly have mediation, and that's going to make a difference. For the most part, public employees do not have the right to strike. So where we spent last week talking about the right to strike and that it is generally allowed, that's the case of private sector employers, but not in the case of the public sector union. And that was, and you may have in your material on the handbook, or in the material on Blackboard, a case, Postal Clerks versus Blount, B-L-O-U-N-T. And in that particular case, an individual was prohibited from accepting or holding a position, or the ruling from that court case was that an individual is prohibited from accepting or holding a position in the federal government if he or she participates in a strike against the government. So if you participate in a strike against the government as a governmental employee, you can be terminated. And in fact, that's what happened. Particular clerks worked for the post office. They felt the right to strike was a fundamental right, even though it was prohibited. They felt that it was a fundamental right protected by the Constitution. As an employee of a government entity, they knew they had constitutional rights, and basically they said, let's go test this. Do we have the right to strike, or don't we have the right to strike? And that was the issue. Do public sector employees have a constitutional right to strike? And the court held no. There is no violation of constitutional rights. They can still join the labor organizations. They can still have grievances. But the government is at all times obligated to function without interference, and therefore prohibiting strikes is reasonable, and it is not a constitutional violation. Now, we talk about detail, more than you've wanted over the last several weeks, about the National Labor Relations Board, the National Labor Relations Act. In essence, you have a Federal Service Labor Management Relations Act. I'll say that again. The Federal Service Labor Management Relations Act, or the FSLMRA, is really the structure for labor relations in the public sector. Now, this act created the Federal Labor Relations Authority, the FLRA, that is the Federal Labor Relations Authority, to administer federal employee labor relations. The FSLMRA also granted federal employees the right to organize, to bargain collectively. They can do that, but it also prohibited strikes and other unfair practices. And a lot of those practices are the same as what is prohibited on the private sector side. So this FSLMRA covers federal employees who are employed by a federal agency or who have ceased to work for the agency because of an unfair labor practice. So even governmental employers can't engage in unfair labor practices. It just may be that those unfair labor practices are a little more limited than what the private sector unfair practices are. The FSLMRA does not include the U.S. Postal Service. It does not include the FBI. It does not include the CIA. There are some other agencies it doesn't include. It doesn't include all employees. For instance, if you've got non-citizens working, they may not be included. Basically, this Federal or Fair Labor Relations Authority Act that we've talked about is composed of 3 members. They're nominated by the President. They're confirmed by the Senate. They serve 5-year terms. The FLRA, this Fair Labor Relations Authority, has the authority to determine the appropriateness of units of representation. In other words, who can be organized and who can't be. They have the right to supervise or conduct elections if there needs to be an election. They have the right to resolve issues regarding the duty to bargain in good faith. And they have the right to look at unfair labor practices. So even though it's a public sector, you may still have those same duties of negotiating good faith, of not engaging in unfair labor practices, but you can't strike, all right? The FLAR, for instance, determines who is an appropriate unit, who can be in a unit. Management or supervisory employees of the federal government cannot be in a unit. Confidential employees cannot be in a unit. An organizational unit, or a union, if you will. Employees engaged in personnel work, except those in a purely clerical capacity. Employees doing investigative work that affects national security, they can't be in a unit. Employees administrating the FSMLRA itself, they can't be in a union. And basically, employees primarily engaged in investigation or audit functions relating to the work of units affecting internal security of an agency, they can't be involved in a union. So it has a little more restriction than the private sector. So if you work for the public sector, that doesn't mean that you automatically have the right in every situation to be part of a unit, or a union, if you will. With regard to collective bargaining, we'll just touch on it briefly. The FSLMRA requires that agencies and representatives meet and negotiate in good faith. That's still a requirement, just like it is in the private sector. They have to negotiate in good faith over conditions of employment, all right? Those generally include personnel policies, practices, and matters whether established by rule or regulation that affect working conditions. So they have the right and they have a duty to negotiate in good faith over those. Generally do not have the right to negotiate policies relating to political activity, relating to the classification of a position, or relating to matters that are set by federal statute. All right, so the collective bargaining in terms of conditions may be a little more limited. With regard to wages, most federal employees are not subject to collective bargaining because they're determined by statute. So in the private sector, where we said, hey, wages are clearly not only a subject you have to bargain over, but they're a mandatory subject, that is not the case in the federal government employees or public sector, generally because they're often set by statute. And then the FSLMRA contains a management rights clause that basically says collective bargaining cannot affect the authority of any management official or agency to determine the mission, budget, organization, number of employees. So where you may have the right in the private sector to say, hey, you can't have more than this number of particularly employees over here. You can't set that same. You can't interfere with the rights of the agency. So there's a little more limitation in that case. We talked about, a couple of weeks ago, we talked about this whole idea of an impasse, well, and how you get to it in the private sector and you go to the National Labor Relations Board. Here, In the public sector, there is actually a Federal Service Impasse Panel. It is a body created by the Federal Service Labor Management Relations Act, and it's supposed to resolve impasses. You have grievance arbitration, and frequently you have arbitration. You can appeal it, but the arbitration, as we talked about weeks ago when we talked about arbitration, is generally going to be binding, and that's how you resolve the problem. You also have a little bit different with regard to public sector labor relations. They can prohibit certain political activity by federal employees. So keep in mind when we talk about the constitutional rights that are not guaranteed to the private sector employees, but are guaranteed to public sector employees, there are a couple of laws that say, not all these rights are going to be given to public sector employees. For instance, the Hatch Act, there's a Hatch Act that prohibits political activity by federal employees. You can't take active part in the management of political campaigns. You can't run for office in a partisan political campaign. You can't engage in political activity while on the job. Now, the purpose of restricting this activity of federal employees is so that you can avoid the appearance of political bias in government actions and to prevent the coercion of federal employees to engage in political action or to support political positions. It's trying to keep the government, if you will, out of that. Not always successful, but that's kind of the purpose. So along with that is First Amendment rights may actually be curtailed a little bit. Give you the example in the case that you'll have in Blackboard. We cite the case of Garcetti, Garcetti versus Ceballos. And Ceballos was a deputy district attorney for the Los Angeles County District Attorney's Office. He was contacted by a defense attorney about a pending case, told that there were certain inaccuracies. He investigated it, and he did, in fact, find there were real problems, that some of the things in the affidavit were wrong, that the criminal defense attorney was absolutely right, and maybe there was a problem. He informed, this deputy district attorney informed his supervisors, wrote a memo recommending the dismissal of the case, said we don't have any right here, and the supervisor decided, you know what, we don't really care what you say, we're going to go ahead, we're going to prosecute this case, and by the way, we're going to terminate you. And they transferred him, or denied him a promotion. I guess they didn't terminate him, but they denied him a promotion, to which he turns around and says, look, I'm a federal government employee, I have the right, First Amendment rights, that's what I was exercising, and you can't now retaliate against me because I've exercised those rights. And the court said, you know what? While the First Amendment, or the issue was, does the First Amendment protect a government employee from discipline based on speech? And the court said, you know what? The Constitution protects public employees while they're not on their duty, but the Constitution does not protect public employees who make statements pursuant to their official duties. And here, it was felt that the district attorney was making his statements, whether he was right or wrong, that he was making those statements as his role as an attorney, not as his role as a private citizen. And if he had made those as a private citizen, he may have been protected, but not in the situation of using his job. So that kind of comes into play as well. There are, just to kind of summarize, and then to sum up this last unit, there are some state laws as well that deal with labor relations and public sector. Basically, there are 40 states that have adopted provisions that are similar to federal laws. These states differ in a large variety of ways with regard to their treatment of issues. But basically, if you're in a particular state and you're looking at a public sector labor union, then you may have to look at that state's statute, because sometimes they deal with how collective bargaining is done. They deal with what rights can be restricted and what rights can't be restricted. They generally deal with strikes, picketing, and patrolling, and things of that nature. Most of these state laws say that, hey, you simply cannot, if you're working for a state agency, you simply cannot strike. There are some states, you don't have to remember this necessarily, but Hawaii, Michigan, Pennsylvania, Vermont, they do allow strikes by employees whose jobs don't affect the public health, safety or welfare. So if you're in a public agency that may not affect health, safety, or welfare, then maybe you're allowed to strike, maybe not. Those penalties for illegal strikes vary from state to state. New York's law prohibits all strikes by public employees and says that employees who participate in illegal strikes may face probation, loss of job, and loss of pay. So those are issues that you just have to keep in mind. I don't want to spend a great deal of time, didn't want to spend a great deal of time on federal public sector relations, but I think it's important when we look at this context of employment law and labor law, how the public sector may in fact differ from the private sector. I've enjoyed this class, and if you have any questions, feel free to give me a call.